Hey guys, cool song, right? Well, who do you think should own the intellectual property rights to a song created by a robot like Bender? Do you think it should be Bender, his owner, or no one? Well, we're Group 4 from IST 432, Legal and Regulatory Environment of IST, Fall 2017. We're going to help you understand the question of who owns intellectual property rights and IP rights for works created by artificial intelligence. I'm Aaron Lewis, and let me introduce you to the rest of my outstanding team. Up first is team leader Vinny, followed by Stephen G, Stephen W, Bradley, and last but not least, Aditya, who will provide us with a little bit of background on the current state of AI. Take it away, Audie.
While conceptions of artificial intelligence date back to Greek mythology, the field as we know it today was only formally established in 1956 at a conference in Dartmouth. The subject has been extensively explored over the years in science fiction, but so far, real life has been unable to live up to fantasy. Research stopped and started in the 70s and 80s before finally taking major leaps and bounds in the 90s, most notably with the creation of the Deep Blue supercomputer, which managed to outclass the reigning chess world champion in a game.
Around the world, artificial intelligence is one of the fastest growing technologies. AI is seen in many different fields. From being used in video games to helping with voice recognition, AI is extremely flexible in its applications. AI has created paintings that resemble a famous painter Rembrandt by analyzing different strokes in previous paintings, has developed its own language, and has even created sounds never heard by the human ear. With AI being able to create these different products, the question of who owns these items comes up. US laws and policies are currently in place that determine who owns these products.
As it stands today, there have not been many cases of artificial intelligence having intellectual property right disputes. However, even though there aren't any precedents set directly by AI, there are guidelines laid out by the U.S. Copyright Office that can be applicable. The U.S. Copyright Office, in its latest compendium, stated that in order for a work to be copyrightable, it has to be an original work of authorship, and the work has to be created by a human being. The U.S. Copyright Office specifically states that it will not register works created by nature, animals, or plants, work purportedly created by supernatural or divine being, or works produced by a machine or mere mechanical process that operates randomly or automatically without human input. Necessarily speaking, artificial intelligence also fall into this distinction because although AI are created by humans, they create their own works of original material without any human input. Examples of non-copyrightable works would be a monkey taking a selfie, a musical work with the Holy Spirit as the author, a mechanical weaving process that creates irregular shapes in fabric without any discernible pattern, or even artificial intelligence that recreates the works of Rembrandt. Any of these works would, necessarily, fall into the public domain as they do not qualify as protected works of authorship, and it seems as though AI would suffer the same fate under the current laws. To further illustrate this point, Stephen W. and Brad have researched a case where this guideline has been applied.
David Slater, a nature photographer, spotted a crested macaque in the Tengkoker Reserve in Indonesia. He left his camera on the ground for the monkey, Naruto, to investigate. Naruto took a series of photographs, including the selfie, which were then published in Slater's photography book. PETA filed a lawsuit claiming that since Naruto took the photos, he should have the legal rights to own and benefit from them. They lost the court case because the judge ruled that non-humans could not own copyrights as they could not benefit from them. PETA appealed the decision and ultimately reached a settlement outside of court where Slater would donate 25% of all future profits towards Naruto, his family, and the reserve in which they live.
So why is this case important when discussing IP ownership with artificial intelligence? Current US copyright law does not allow for anything to be copyrightable when created by a non-human actor. The judge in Naruto ruled that non-human actors like Naruto don't have ownership over intellectual property they may create because they cannot receive value from it. Artificial intelligence falls under this non-human distinction, and the same principles apply to them.
Now that we've seen these U.S. copyright guidelines applied to Naruto, let's connect it to artificial intelligence technology. At Rutgers University, scientists in the Art and Artificial Intelligence Department have created an artificial intelligence known as the Creative Adversarial Network, or CAN. This network uses deep neural learning to study artistic styles such as Baroque, Rococo, and Gothic. The AI has studied over 8,000 paintings from over 1,000 painters. After studying this material, the AI was able to create its own works, which were displayed at an art show. Of the works, the abstract expressionism pieces created by the AI were able to fool 85% of the people that viewed them into thinking that the paintings were actually produced by a human rather than the AI itself. This clearly shows how human AI could be, and how original and novel its works can be.
Although the can was created by humans, it used autonomous processes to create its works. This means that, unfortunately, it falls under the non-human actor distinction. Also, the AI cannot technically gain any value from these works that it creates. This means that works that the can creates cannot be copyrighted and fall into the public domain. Any individual in the world can reproduce, redistribute, and display these works without providing credit to the source. Ultimately, our research question has been answered, as it seems all works produced by AI fall into the public domain.
So that concludes our discussion on who owns intellectual property and IP rights for works created by artificial intelligence. Our group remains split on the issue. Some think that AI-created content should belong to the owners of the AI that create it. The rest of us think that it should be in the public domain where it belongs. Regardless of what you believe, thank you for watching this video. I hope you have a better understanding of this issue and how it will only become more relevant going forward.